Welcome to this joint initiative by LAWASIA and the American Bar Association that is focused on the challenges to the rule of law in the Asia and Pacific region in this time of the COVID-19 pandemic. This initiative is aimed at specific threats to the rule of law, particularly attempts to dilute or negate fundamental rights, and it is also to ascertain concrete steps that bar associations in the Asia-Pacific region can undertake to support the legal profession in upholding the rule of law. Ladies and gentlemen, there have been many casualties in this COVID-19 pandemic. One of them is the rule of law. We have seen a steady erosion of fundamental rights under the cover of combating the pandemic, and this has in many cases led to executive overreach. Bar associations and lawyers have struggled to uphold and preserve the rule of law in the face of public health concerns, either genuine or exaggerated for ulterior purposes. The need for vigilance in the protection of the rule of law and fundamental liberties in these challenging times was alluded to by Lord Sumption, the retired UK Supreme Court judge, and I quote, "When societies lose their liberty, it is not usually because some despot has crushed it under his boot. It is because people voluntarily surrender their liberty out of fear of some external threat. Historically, fear has always been the most potent instrument of the authoritarian state. This is what we are witnessing today." Unquote. This webinar is the second installment in a four-part series of webinars. In the first webinar, we looked at the experiences of bar associations in confronting the impact of the pandemic to their functions. Today, the discourse is on freedom of speech and expression, personal privacy, and the effect of fake news and doxing laws. By fake news or post-truth laws, that is broadly intended to counter the dissemination of misinformation. Doxing concerns, in the main, the unlawful disclosure of personal data with the intention of shaming or victimizing. Our panel of speakers will consider to what extent these laws either limit or extinguish freedom of speech and expression, particularly on the justifiable grounds of reasonableness or proportionality. Put differently, the question for us today is whether fake news and doxing laws comply with the basic canon of interpretation that requires fundamental rights to be construed as broadly as possible and laws that purport to limit such rights to be construed as narrowly as possible. My name is Stephen Thiru. I'm Vice President of LAWASIA. With me, there are sessions report to us because after each session, LAWASIA and the American Bar Association will compile a report detailing lessons learned and actionable steps that bar associations across the region can take to effectively balance the need to respond to the pandemic with protecting the rule of law in the context of their own country. Our sessions rapporteurs will be responsible for drafting the action report on the best practices and recommendations that we will be exploring today. A copy of the action report will be sent to everyone who has registered for today's event. May I first introduce the sessions rapporteurs. Sarah Sanford, a transactional attorney for over 30 years and a qualified mediator. She is the former chair of the ABA International Law section and has served in a number of other capacities in the section and within the ABA, including co-chair of the section's International Human Rights Committee and the Asia Pacific Committee, ABA liaison to LAWASIA, and chair of the ABA Rule of Law Initiative, Asia Regional Council. The other rapporteur is Mustafa Aija Zudin, an assistant public defender with a keen interest in international law, having published last year an analysis of international instruments to address state-sanctioned mass murder, harm, or oppression of religious and ethnic minorities. With that, I wish to now invite our first speaker to deliver the welcoming remarks, and that is Melissa Pang, the President of LAWASIA. Very briefly, Melissa is the immediate past president of the Law Society of Hong Kong, and she has been serving as Law Society Council member since 2005. Melissa was admitted as a solicitor, has been admitted as a solicitor in Australia, England, Wales, and Hong Kong. Her main areas of practice are commercial law, property law, and litigation. She's a partner of Pang & Associates. Melissa assumed the presidency of LAWASIA in November this year. Melissa.
Thank you. Ladies and gentlemen, it is my great pleasure to welcome you today to this webinar, Freedom of Speech, Expression and Personal Privacy, Fake News and Doxing Laws, which is a joint initiative between LAWASIA and the American Bar Association, ABA. My name is Melissa Pang, and I am the president of LAWASIA, which is a regional law association of lawyers, judges, jurors, and legal organizations. We represent and advocate for the interests of the legal profession in the Asia-Pacific region. It is a privilege to collaborate with the ABA again. This is the second webinar of LAWASIA and the ABA's four-part virtual dialogue series, which is looking into the threats to the rule of law in Asia, stemming from the COVID-19 pandemic. I look forward to the action paper, which will be published following the completion of the series, which will outline concrete steps for legal organizations to respond to these challenges while maintaining the protection of the rule of law. Whilst misinformation is not new, the proliferation of fake news has accelerated, and misinformation relating to the pandemic has become commonplace on the internet and more broadly in our society. Governments in the region are looking to, or already have, adopted laws to stem the abundance of inaccurate and misleading information, as it has the potential to negatively affect public health and the implementation of life-saving vaccines. However noble this intention may seem, unfortunately, we are seeing governments use these kind of laws to clamp down on criticism and entrench authority. We have seen bar associations, in particular, be targeted by the kind of laws that attempt to silence those seeking to maintain the rule of law. The act of doxing, that is publishing documents containing personal information for the purpose of harassment, is troubling. And the laws need to be developed to respond appropriately to protect individuals. Again, these laws can be double-edged, as prohibiting the publication of sensitive information, which can be used by government to protect their own information. The ability to remain anonymous is vital, as unauthorized disclosures through whistleblowing and journalists who report on disclosures protect the advancement of the integrity and transparency in public life. Thankfully, we are drawing upon the expertise of our guest speakers today to draw these nuisances and discuss how bar associations and legal organizations can retain their independence and the privacy of their members amidst the competing aims of governments seeking to further their power. Let us not underestimate the importance of gradual changes as the sequence of small changes aggregate into larger ones. I look forward to the discussion of this very important topic today. Thank you.
Thank you very much, Melissa. For the second welcoming address, we have Ms. Deborah N.X. Ross, the President-elect of the ABA. Deborah is unfortunately not able to join us today, but she has pre-recorded remarks. Deborah is a senior advisor to the International Dispute Resolution Group of DeBewas Pimpton in New York. She served as chair of the American Bar Association's Policymaking House of Delegates and as chair of the American Bar Association's Center for Human Rights. She's a fellow of the American Bar Foundation and has served as vice president of the World Justice Project and vice chair of the IBA's Bar Issues Commission. Deborah has a BA in broadcast journalism from the University of Miami and a JD from the University of Miami School of Law. She was conferred a diploma in comparative law from the Parker School of Foreign and Comparative Law of Columbia University. You will now have Deborah's pre-recorded welcoming address. Thank you.
Thank you, Stephen, and greetings to everyone joining us for the second dialogue in our series on bar associations and the pandemic response. The American Bar Association is pleased to collaborate with LAWASIA and President Pang on this initiative. The pandemic continues to demonstrate just how interconnected we are, and we've all felt the devastating effects of COVID-19 in each of our countries. We've also seen the importance of collaborating and sharing information in meeting this challenge successfully. In the first dialogue of this series in September 2021, participants spoke openly about the challenges they faced from the pandemic. Each of these challenges demonstrated the importance of bar associations in responding effectively. Our dialogue explored concrete actions that bar associations and lawyers can take, from advice on establishing hybrid, virtual, and in-person hearing structures to engaging lawmakers more directly during crisis. We understand that what works in one jurisdiction may not work in the same in another. But we hope that by discussing these solutions, you can find inspiration to meet the challenges in your own jurisdictions. Today's dialogue, Freedom of Speech, Expression, and Personal Private Privacy, Fake News and Doxing Laws, explores an important, nuanced challenge that has been brought to the fore because of the devastating effects of misinformation and disinformation in the context of a global health crisis. More generally, misinformation and disinformation can have disastrous effects in a free society. It is said that democracy is not a spectator sport, but in order to participate, one must know the rules. Democracies are founded on the principle of diverse voices coming together to address social challenges and to hold governments accountable. This goal is subverted when the marketplace of ideas is polluted with false or misleading information. The spread of false, deceptive, or misleading information threatens the integrity of democratic institutions and the foundational democratic principles of the rule of law. This risk is amplified by technological innovations that are used for nefarious ends. Technology now makes it possible both to corrupt otherwise legitimate messages and to facilitate the spread of false, deceptive, or misleading information. The global reach of social media, a key channel through which dis and misinformation travels, knows no borders. Even before the pandemic, we were seeing the troubling impacts of mis and disinformation. A 2018 report by the US Department of Justice concluded that disinformation campaigns were a key strategy for undermining elections. In the same year, the ABA's Standing Committee on the American Judicial System identified the unprecedented risk unjust criticism and misleading statements against the judiciary could have on judicial independence and the functioning of the US legal system, concluding with key steps for bar associations to take in addressing this challenge. The collection of vast amounts of data exposes individuals to new risks, and it enables bad actors to dox citizens and public officials, upending their lives and putting them and their families at risk. Few legal protections developed to date draw a line around the legitimate use of sharing information. When does accountability become aggressiveness? The transnational nature of the challenges posed by disinformation and doxing only add to their complexity. As lawyers and judges, we see the darker side of how laws passed without contemplation of these risks and embedding effective protections can have equally devastating consequences. Our perspective as legal experts is essential to ensure that laws protect the free flow of ideas along with individual rights and privacy. The ABA's collaboration with LAWASIA provides an important platform for dialogue to protect and promote the rule of law. We hope that through our conversations today, we can begin to develop ways for bar associations across the world to respond to the challenges our societies face while protecting the rule of law and improving the practice of the law.
I wish to thank both Melissa and Deborah for those welcoming remarks, which take us very nicely to the panel discussion today. But before I introduce the panelists, may I just encourage participants to place questions that you may have in the chat box so you can take on your questions. The topic is, of course, a topic that lends itself to many questions, I think, and we are looking forward to a robust discussion, question and answer session, and we're going to try and allocate as much time as possible for that. Speakers have been told that to limit their presentations to about 10 to 15 minutes, so that will give us ample time to take on questions. So please, if you could, put your questions into the chat box and we will take them on as soon as we can. The first speaker for this afternoon, at least afternoon in Malaysia, is Phil Robertson, and it's afternoon for Phil too because he's in Bangkok. Hello, Phil, how are you?
Very well, thank you so much.
If I may just introduce Phil briefly, he's got a very long and impressive CV, and I don't do any justice to it by just reading this. Please look up his CV. He's the Deputy Director of Human Rights Watch Asia Division. He oversees the organization's work throughout Asia, with a special focus on Southeast Asia and the Korean Peninsula. He serves as a human rights advocate engaging with government and UN agency officials. Prior to joining Human Rights Watch in 2009, he worked for 15 years in Southeast Asia on human rights, labor rights, protection of migrant workers, and counter-human trafficking efforts with a variety of non-governmental organizations. Phil is a 1997 graduate of the Johns Hopkins School of Advanced International Studies, and he's fluent in both Thai and Lao. Phil will give us a regional overview on freedom of speech and expression, indeed an index on where we are today, or if you like, a thermometer on where we are today in the protection of these fundamental rights during the pandemic. Phil.
Thank you so much, Stephen, for that introduction. I really appreciate it. As you mentioned, my name's Phil Robertson, and it's a pleasure to be here to talk about these important trends across the region. I want to thank the ABA's Rule of Law Initiative and LAWASIA for taking up this important matter, which is something that we at Human Rights Watch has been very seized with. I'm the Deputy Director of the Asia Division. I'm responsible for our work across Southeast Asia and the Korean Peninsula. But the issues we're talking about affect regions across the region, such as China, South Asia, parts of the Pacific. Others at Human Rights Watch handle some of those issues. But I think some of the themes I'll discuss will sound familiar to some of you from those areas. In any case, I hope we have sufficient time for discussion at the end of the presentations to cover issues and country situations that I won't be able to cover in this overview. I was asked to provide a regional interview on fake news and anti-doxing laws, but I will primarily concentrate my efforts on the fake news side of this discussion, because that is where much of Human Rights Watch's focus has been, as we have watched freedom of expression online take hit after hit during the almost 2 years that we've been facing the COVID-19 pandemic. And I must say at the outset that as an American, I have to apologize for the role that the former US President Donald Trump played in popularizing the so-called fake news phenomenon, giving leeway, in our view, to many countries in Asia and around the world where leaders recognized and grabbed on to an opportunity to characterize information, viewpoints, and opinions, and in many cases, facts that they don't like as somehow being fake or false. It's rather bizarre and surreal that the one American leader who has arguably engaged in more outright lies than any other would be the global messenger claiming he was against fake news, but here we are. And in fact, we at Human Rights Watch realized that the minute Cambodian Prime Minister Hun Sen started extolling Trump's words about fake news, I knew we were in for a hard ride. From Singapore to Thailand to Vietnam and elsewhere, we've seen this opportunistic seizing of the anti-fake news agenda by leaders keen to diminish challenges to their political, economic, and social narratives. It's a very attractive appeal for those leaders to use these extremely broad, easy to manipulate legal criteria of what constitutes fake news to label inconvenient truths as false and then claim to the populace that they were censoring or eliminating such information. And by doing so, the government is doing something good or appropriate for the people. Add to that the easy mobilization of bias through catchy appeals against anything labeled as fake news, and the stickiness of fake news labels to whatever has been so tagged. And it's no wonder that governments are setting up fake news control centers, committees, and other administrative mechanisms across the region to try to tackle and control the fake news phenomenon. We've seen that the COVID-19 pandemic has in fact created risks for the government across the Southeast Asia region. And conversely, for the authoritarian minded, it has also brought opportunities for exerting greater control over their populations. The largely effective response to the COVID-19 pandemic that carried through much of 2020, when governments in the region locked down, constraining travel in and out of their countries, gave way to disastrous spreads of the virus as the contagiousness of the Delta variant overwhelmed prevention measures. We saw countries like Malaysia, Thailand, and others get caught out badly when their slow responses to procure adequate amounts of vaccines came to the fore. And other countries like Cambodia and Vietnam were criticized for their harsh lockdowns and in some cases deprivation for affected communities who were not able to get basic services and goods. And the social media critiques going viral about rollout plans, corruptions, efficacy of procured vaccines, like those from China in particular, which was criticized in some places, although we at Human Rights Watch don't take a position about efficacy of vaccines. The weak government responses prompted real defensiveness, I think, among governments, especially as their popularity with the public plummeted because of the spread of the COVID-19 virus amongst their populations. And I'm going to go and briefly sort of highlight how this has played out in fake news regulations controls for some of the governments, where they sought to impose on their publics because these controls were very significant impacts on the right to freedom of expression online. And some countries resulted in people facing trial and going to prison, as we've seen in Cambodia. Couched in formulations of public health policy, and in some cases with attempts to justify on public health exemptions, international human rights law, and too frequently implemented by emergency legal authorities, these fake news laws and regulations have been particularly hard to resist. And this has been a difficulty for bar associations and other organizations, NGOs, activists who have tried to get ahead of these kind of regulations. Under international human rights law, governments have an obligation to protect the right to freedom of expression, including the right to seek, receive, and impart information of all kinds. In fact, governments may only impose restrictions on freedom of speech if those restrictions are provided by law and are strictly necessary and proportionate to achieve a legitimate aim, including the protection of national security, public order, public health, and morals, the rights of others. Of course, any such restrictions must also be written sufficiently clearly that those subject to law can understand what is prohibited. And this is, I think, a fundamental failing that we have been seeing across the region, that these laws are written very broadly in a way that allow maximum discretion for the implementing officials, ministers, and others. This standard is, in fact, what the governments are fundamentally failing to meet. And upholding these standards, as they're written in international law, I think is probably the one major recommendation that Human Rights Watch would make in terms of tackling this fake news crisis that people have identified. Now, not every issue in society can be solved by a law, and what we're seeing in some cases is governments dealing with fake news in a prejudicial manner, using overly broad laws and regulation to give maximum discretion to ministers. And if we look at some of the places where this has happened, I would point out places like Malaysia. Malaysia, we saw the reintroduction of a fake news law on March 11, 2021. This was the Emergency Essential Powers No. 2 Ordinance. And this came in effect the next day, March 12th. There was really no public consultation. And while the proclamation of emergency that lifted on August 1st, 2021, is remember the draconian nature of this ordinance. The ordinance made it a criminal offense to create, publish, or disseminate fake news relating to COVID-19 or the proclamation of emergency in the country. And it required access for police to traffic data and computerized data upon request. And it allowed for corporate directors and other executives to be held criminally liable for company actions. The ordinance provides sentences up to 3 years in prison. And fake news was very broadly defined as, quote, news, information, data, reports, which are wholly or partly false. Again, the discretion being completely up with the regulators on what can constitute wholly or partly false. It failed to provide standards for determining what that question is. What is false? Raising the risk that it could be used to silence criticism or other speech that the government didn't like. Now, I think that the Malaysian bar, like many others, were very surprised by this. And in fact, there was a great deal of consternation that the anti-fake news law that had been passed in 2018 in the sort of waning days of the government of Prime Minister Najib Razak and been repealed in 2019 was coming again to the fore in a different form. Fortunately, of course, with the end of the emergency decree, these issues are resolved. But in Thailand, we had a similar situation where there was a major showdown on freedom of expression based again on an action by the Thai government that was granted by emergency decree. And, this was a culmination of a steady drumbeat of actions by the Thai government against perceived fake news. There's a lot of details there that I can go into in the question and answer. But again, the core principles were the vague provisions of existing law, a lack of consultation, a failure by the government to focus effectively on providing clarity to affected publics, presumptions throughout of bias and potential use of these laws against other forms of speech. And, this was against also the background of a law, the Computer Crimes Act, which is also quite restrictive and which has been used again and again to prosecute people for information they put online. Now, ultimately in Thailand, again, there was a challenge to this decree that was passed by the Prime Minister. There was a major outpouring of support for efforts to try to repeal this. The legal challenge was finally taken up by the Thai civil court, and an injunction was issued, which finally, combined with, I would say, significant political opposition from civil society, from newspapers, from UN agencies, from embassies and others, who really saw that it was a significant overreach, finally decided that, okay, this is too much. And the government itself decided to revoke the law when it realized it was going to face an ongoing crisis because of the actual law itself. If we switch to Cambodia, the Cambodians have been less lucky, and we have seen, in fact, prosecutions under even more vague provision, the incitement to commit a felony, which has been used to criminalize fake news allegations made by the government. And Human Rights Watch right now counts more than 30 people who have been charged with statements they made with regard to COVID-19 or the government's response. Vietnam is expanded as well. They've got a decree number 15 of 2020, which was passed in February 2020, which again has increased administrative penalties for fake news in addition to the existing civil and criminal penalties. This is a small snapshot, but what it shows is that we're seeing a expansion of government authority using fake news as a primary justification, also riding on the back of this COVID-19 pandemic, and creating a situation where governments are significantly expanding their controls over the internet, over online expression of all sorts, and creating a crisis of, in some cases, self-censorship by media, certainly cases where people are being charged, especially if they're politically active, because they're already under surveillance or in the crosshairs, and ultimately, I think, creating a crisis of expression on the internet. This is being justified on the basis of a fake news crisis that the governments have discussed. But if you actually look at the numbers of articles that are reviewed by governments versus the number of cases of fake news which are clearly identified, it's a very small number. So the question we would have is, where exactly is this crisis that everybody says, and are these laws being used in a way that is going to restrict freedom of expression well beyond what is justified by the threat of so-called fake news? So I'll leave it there. I think there's a lot of exceptions to this. There's a lot of different examples that can be brought. This is really about trying to create a sort of starting point for discussions about exactly what sort of crisis we're facing here.
Thank you very much, Phil, for that survey, a very useful survey of how I think the fake news laws have been misused. And I think one of the points that come out very clearly from your presentation is where these laws are now used to stifle legitimate criticism of governments. At this point of time, it is somehow linked to pandemic and pandemic issues. But I think we can see that these laws are there to stay. They're here to stay, and it'll be, after the pandemic is gone, it'll be other avenues of criticism would be shut down by the use of these laws. That's a very useful survey of some of the key jurisdictions in the Asia Pacific region. We will now look at two specific jurisdictions and how they have handled fake news laws as well as doxing laws. First, Hong Kong, and we are privileged to have Robert Pang, SC, from Hong Kong. Robert is the former vice chairman of the Hong Kong Bar Association and has served the Bar Association in various roles. He's a barrister with a broad range of practice, from criminal to civil and matrimonial matters, appearing in all levels of courts, from the magistrates to the Court of Final Appeal. Indeed, I believe he was recently involved in the Jimin Lai case, where I think the sentencing was just a few days ago. He was called to the bar in 1998 and appointed as senior counsel in 2012. He's a fellow of the Chartered Institute of Arbitrators, a fellow of the Hong Kong Institute of Arbitrators, and an accredited mediator. He's also served in a judicial capacity as the Deputy High Court Judge. Robert will speak on the Hong Kong experience on fake news laws and doxing laws. Robert. Robert, you're muted. You need to unmute.
Okay.
All right.
Here we are. Thank you very much, Stephen. It's a pleasure to be here, and thank you for having me here. I'm just here to talk a little bit about Hong Kong and fake news and doxing laws. We are going to talk more in the Hong Kong context about doxing laws because fake news has not had the same amount of attention as doxing in Hong Kong. But the government in Hong Kong is already looking at drafting legislation to deal with fake news. Reports are out there. They are studying the conditions and the experience of other jurisdictions. And although the government says that criminalization will be a last resort, they don't exclude it altogether. We can see a lot of problems with this. And problems have already been raised, particularly who will define what is fake or what is not. And there is the possibility of using fake news legislation to deter hard-hitting journalism. I mean, Hong Kong has always had a pretty free press hitherto. It's getting a bit less free nowadays, but then that's another matter. But that's a problem that has been recognized and that the journalists in Hong Kong are very worried about. But going then to the main part of my discussion, and that's doxing laws. Now, the reason why Hong Kong is probably very much at the forefront of anti-doxing laws, not because of the law itself, but because of the problem of doxing. There was widespread doxing that was brought about by the protests in 2019. For those of you who are unfamiliar with that, in 2019, the government attempted to introduce a law to enable the fugitives to be rendered to mainland China. That met with huge opposition, lots of protests, and protests throughout Hong Kong. That also gave rise to allegations of police brutality, and also because of these allegations of police brutality, there was widespread doxing of police officers and their families. Now that comes, I suppose, because some people feel that they are somewhat powerless against the police, rightly or wrongly. But it gave rise to a very serious situation where the police officers, individual officers' personal details were released all over the internet, and even worse, that of their families, children. Their kids were ostracized in schools because their parents happened to be police officers. Now, there was no pre-existing legislation in Hong Kong to deal with that. And in that situation that we found ourselves in, it would have been very difficult to pass any legislation at all. So what happened was that Hong Kong, being fairly creative as it always has in finding legal solutions, someone came up with the bright idea of doing it by way of a civil injunction. Now, the civil injunction is actually, there have been a number of them, but the first of these was something to do against the police officers. And I can probably bring up on my screen, I'll share a screen with everyone, the terms of the injunction. And that is here. Can everyone, oops, bit of a technical problem here. Right, can everyone see the screen? If that's okay, then you can see that it's not against any named persons. It's against persons unlawfully and willfully conducting themselves in any of the acts prohibited under paragraph 1A, B, or C of the endorsement of claim. So there's actually no defendant, named defendant, and no one has actually intervened to try to challenge this case. And it doesn't, and it identifies the defendants by the exact acts which are the subject of the injunction. Now, of course, there's a problem, of course, with circularity, but then that's not really been a problem that anyone has argued, because no one really wants to argue that they have or have not been, as we see here, using, publishing, communicating all the personal data and so on. And you can see the sort of details that led to this sort of injunction. And this was in relation to police officers, spouses, and respective family members. You can see the intent, the original order was fairly widely drawn up. It was then reduced, amended to set out that the injunction covered only acts which intended or were likely to intimidate, molest, harass, threaten, pester, or interfere with. So of course, these sort of, although no one actually came up to defend these acts or to stop the injunction, there were a number of hearings, particularly where interveners came in. The Hong Kong Journalists Association came in to try to limit that, and there were certain exceptions for journalists. So that came in, and then it was actually fairly effective, because there have actually been a number of persons who have been cited for contempt. Now, the Secretary of Justice took the lead. So this was actually a government-led initiative, and although it's couched as a civil injunction, it was actually taken up by the government, and the Secretary of Justice, in fact, took the lead in citing people for contempt. Now, my search dug up about 5 persons who have been cited and who have invariably pleaded guilty. With a criminal contempt, one can expect custodial sentences, and all of them received custodial sentences. Majority of the custodial sentences were suspended, but not all of them. One of those persons was sentenced to 21 days immediate custodial sentence. So, and some of them had to pay costs of the government. The costs varied from fairly minimal amounts to some substantial amounts, but there has been a warning that in the future you can be looking at indemnity costs and months in prison. So that's actually put a stop to a lot of these doxing, because no one really wants to pay hundreds of thousands of dollars in costs and face months in prison for. But you can do that if you inadvertently or very quickly simply forward a post. But then that's how that was dealt with. But doxing is not just in relation to police officers. There's doxing of judges, and that led to another injunction. Judges and judicial officers. Some of them, the problem of doxing with judges and judicial officers led to even their wives having not using their telephones, personal telephones. Giving this information out leads to people actually not only making nuisance calls. It led to people even signing organ donation forms or mortgage loan applications, and all totally harassing actions. So it was very distressing for all those involved. And not just judges, there were in fact other persons, even protesters, were the subject of doxing. Now, I acted for one of the protesters who was fairly well known. She was hit in the eye with a beanbag round, and she became a little bit of a cause célèbre for the protests. She was subject to extensive doxing to the extent that she had to move from her residence, not just once, but repeatedly, because people were coming up, asking funny questions. She was really worried about her own safety. So doxing can be a problem with from all sides of the spectrum. That's led to an amendment to the Personal Data Privacy Ordinance to criminalize doxing. That can now be criminalized with a maximum of 5 years imprisonment. Now, of course, there are various problems about how that's going to be enforced. There has been the first arrest. We'll see how everything, how that all pans out. But we still don't know and what the how it's going to be actually the defenses built into the legislation are going to pan out. Now, apart from the privacy ordinance, there have also been other knee-jerk, and I'll say that that's mainly pretty much a knee-jerk reaction to things. The elections registry, because the police officers were so worried about doxing, they took out an injunction against the election commission to prevent details of their personal details as electors from being published. Now, the background to that, of course, is that there has been an electoral roll. The electoral roll contains both their names and addresses and so on from being published. Now, they got an injunction, which was upheld in the Court of Appeal. And the upshot of it is that apart from the political parties themselves, no one else can actually see or the information, linked information, that's names linked to addresses. Now that opens the way for possible voter fraud. We did manage to get, of course, an exemption in relation to the journalists, because the Hong Kong Journalists Association intervened in that case and allowed, and so the courts allowed journalists to be also provided with the copy of the information. But then there had already been really significant steps already in place, even before the injunctions, that would have made it very difficult for anyone to really look at the information. Now, of course, the full list was provided to candidates, but for anyone else who wanted to actually go and inspect, you had to go with no pen, no paper, and just memorize things. So even with reporters, so there was already a very, very stringent conditions, but still even more stringent conditions were set out. So now no one can really inspect those registers. There have been other restrictions, traffic plate number search. Previously, you didn't really have to specify any particular reason. Now, in their form, that you need to specify a reason. Companies registry. There have been changes, recent changes in the details that you need to that are available for inspection. So right now, previously, the director's personal details, including their addresses, names, addresses, ID numbers, were required in the materials available for public search. Now, it's going to be restricted on a step-by-step basis. Firstly, anyone can ask for redacted versions to be on the public register. And then after that, all that sensitive information will be redacted. And the third stage will be even other documents within the company's register with that sensitive information will be redacted. Now, there are exceptions. You can ask for production of those details in full, but we need to see the regulations, and it's all a question of you asking, making the application, and then the registrar may permit the documents to be disclosed. Now, that can be a big problem because of these sort of knee-jerk reactions against doxing, because there can be very many legitimate inquiries, both for instance, traffic plates. Part of my practice is a matrimonial practice, and a lot of that goes into investigations about who owns what. So seeing a car constantly at a particular address can lead to different questions. And if you can't see who that car belongs to, then that's going to hamper a lot of the financial investigations. So you can see the car. So right now, you can see the car plate. You can go search that. Oh, it could go to a particular individual. More likely, it's going to go to a company. Now, if you can't see who's actually behind the company, then there's very little ground on which you can say, well, this husband or this wife has been hiding these assets. These are unintended consequences, or what I would think are unintended consequences of what I would say a knee-jerk reaction. I think there needs to be a more comprehensive, holistic overview of the various interests at stake. Doxing is a big problem, but then so is the requirement for transparency. We do need transparency to hold people accountable in various ways, not just in political life, but in their personal lives. The problem in Hong Kong is that at present, there is very little scope. We don't currently have much of an effective opposition in the legislature. There will be new elections, but those elections, well, that's another topic. I don't hold that much hope for another or any sort of more better electorate or more effective opposition in the coming few months. But the takeaway, I suppose, is that we need to bolster up whatever institutions we have and try as much as possible to maintain an effective presence in the legislature, so that the government can be reminded there are so many other interests at stake without bulldozing through these knee-jerk sorts of reactions to eliminate what is really a serious problem. So with that, can I just hand it back to Stephen?
Thank you, Robert, for that presentation. I'll be very interested later in the question and answer session if you could maybe tell us what was the Hong Kong Bar's position when the amendment came in on the 29th of September 2021. Essentially to put it on statute that the doxing laws were given a statutory basis. And I'm sure the Hong Kong Bar took a position of that. And perhaps maybe in the question and answer session, you could expand on that. Thank you very much again. Can I now move on to our third and final panelists to speak on the Philippines experience on fake news and doxing laws. Oliver Xavier Reyes is the co-founder of the Internet Rights Advocacy Group, democracy.net.ph, and he's a professor at the University of the Philippines College of Law, the De La Salle University College of Law, and the Lyceum of the Philippines College of Law. Oliver was previously senior program manager of the ABA's Rule of Law Initiative, working on projects to automate the Philippines trial courts and to build capacity of lawyers to litigate cases involving freedom of expression, online and online privacy. Oliver has worked for the Supreme Court of the Philippines as a judicial staff head. He has been a member of the Philippines Bar since 2002. As a graduate of the University of Philippines College of Law, where he served on the editorial board of the Philippines Law Journal. Oliver.
Thank you, Stephen. I'll be discussing the Philippine overview on fake news and anti-doxing laws. As I do have a lot of ground to cover, I'll just jump directly to my presentation. Next slide. So, any policy discussion and fake news in the Philippines cannot avoid the evidence of network disinformation, so quote unquote, as practiced here. Deborah had earlier referred to the use of network disinformation in elections, and much has been written about the use of network disinformation during the 2016 Philippine elections. During that time, PR strategists working with political clients successfully built networks for disseminating content in order to build their followings, including through the use of fake news, the use of trolls, and fake accounts. These networks have also been used for non-political purposes, but the sophistication and the success of network disinformation, and especially waging political battles, has been the source of much concern. And as you will see, the object of legislative responses. Next slide. Now, in the last 2 years, another event, the current pandemic, has also placed fake news in the line of sight of Congress and of the government. So Republic Act 11469, which was the emergency powers measure that was passed by Congress just weeks or days even after the initial lockdown in March 2020, included a provision that made it a crime to spread false information about the pandemic on social media and other platforms. This emergency law has expired. It expired only after 3 months. But dozens of arrests were reported in 2020 for spreading fake news. Many of these arrests were effected without a warrant. One such arrest was of a Cebu-based artist named of Maria Victoria Beltran, who was charged upon complaint by the city mayor over a Facebook post claiming that 9,000 new COVID cases had been diagnosed in just 1 day in the city. However, the charges against Beltran were ultimately dismissed in September 2020 by the trial court, which notably not just only ruled that the arrest was illegal, but the post itself, which it deemed satirical, was protected speech. This decision highlights, of course, the value of a judiciary that is willing to assert the primacy of rights protected by the Bill of Rights, even against government action. Again, it should be noted that RA 11469 expired in June of 2020. This provision that would have criminalized fake news in the context of the pandemic can no longer thus be the basis of any subsequent prosecution. Next slide. Yet, even without such emergency legislation that is specifically designed to tackle fake news, current criminal law in the Philippines can already be used to criminally prosecute those who manufacture fake news, as long as the content is deemed libelous. Such concerns, though, to fake news or, frankly, unpopular news could go overboard, raising concerns over the protection of freedom of expression. The phenomenon of cyber libel illustrates the point. Cyber libel in the Philippines is distinctly punished by the Cybercrime Prevention Act of 2012, even though the current criminal libel statute has existed since 1930. Online libel or cyber libel, though, carries considerably different consequences from offline libel, with the justifications for such distinctions hardly warranted. Cyber libel carries a minimum prison penalty of 6 years, unlike ordinary libel, which only carries a 6-month minimum. Offline libel cases can only be filed within 1 year from publication, but such limitation is not textually explicit in the case of cyber libel. And in fact, in the recent trial court conviction of Nobel Peace Prize winner Maria Ressa for cyber libel, the trial court had applied a prescription period of between 12 to 15 years. It is similarly unclear whether restrictions enacted in the 1960s that limit the venue for the filing of offline libel cases to protect journalists from harassment also apply to cyber libel. Unless Congress amends the law, it will entail a definitive ruling from the Philippine Supreme Court to clarify these matters. And one such ruling might very well come in the Maria Ressa case, which is now working its way through the appeals. Next slide. Now let me turn to doxing. The Philippines does not have dedicated laws that were meant to address the current day spate of online doxings. But there are provisions in recent laws that victims can use to either criminally prosecute their harassers or at least compel the takedown of unauthorized disclosures. One of these laws is the 2012 Data Privacy Act, which establishes the right to control what happens to the personal information of an individual. Personal information being any information that can be used to personally and distinctly identify an individual. Malicious and unauthorized disclosure of personal information by those who process or control data, even if it is not publicly disclosed, is penalized by 1 to 5 years imprisonment, although there have been no successful prosecutions to date. Individuals also have the right to compel the takedown of personal information that is disclosed without their consent, as well as for several other grounds, including the so-called right to be forgotten. There is a significant exception, though, one that would address some concerns from a freedom of expression standpoint. The Data Privacy Act specifically excludes from its application disclosures that are made in the exercise of journalism or for artistic or literary purposes. And this exception was specifically carved out in order to respect the freedom of expression clause in the Constitution. Since the law is a relatively recent enactment, we have yet to see any judicial interpretations on possibly contentious questions, such as, for example, whether citizen journalists can invoke the journalism exception as to them. Next slide. An even more recent law is the Safe Spaces Act, which was passed in 2019. And this law addresses several modes of sexual harassment, including online harassment. Now, worth noting is the definition of gender-based online sexual harassment, which is an act that is criminalized. Now, the definition you will find in Section 3E, or as seen in bullet point number 2. Gender-based online sexual harassment denotes, by its name, that gender relations between the offender and the victim are a definitive element of the crime. But the definition under the law also broadly includes acts that constitute invasion of privacy through sharing any information online about the victim, perhaps irrespective of the motive. Based on the text of the law itself, a victim of doxing may be able to invoke gender-based online sexual harassment, even if the motive for doxing was political in nature. But perhaps the broad drafting of the law may also lead it to susceptible to questions about its constitutionality on the ground of overbreadth. Next slide. Now, going back to fake news, there have been several bills that have been filed in the current Congress that attempt to criminalize or address fake news. However, and I will be very candid about this, none of these bills are likely to be enacted before Congress adjourns in June of next year. They remain right now pending in committees. They have not been certified as priorities. They don't have counterpart measures, and we have in the bicameral legislature. So I really won't dwell on these bills, except perhaps to point out that fake news is of a sufficient public concern that legislators, or at least some legislators, feel compelled to respond by drafting bills. Next slide. There are two bills, though, that I consider of particular interest, and perhaps also bills that other jurisdictions might end up studying. One measure, and this one is I would be comfortable to personally endorse myself, is Senate Bill 1479, which would amend the current Code of Conduct and ethical standards for public officials and employees by obligating public officers and employees not to disseminate false news or information, whether in their official or personal capacities. And this prohibition is based on what should be an indisputable premise that fake news or information emanating from the state erodes trust in the government itself. Next page, next slide. Another measure worth highlighting is House Bill number 1324, which would mandate social networks to verify the identity of social media account users to prevent several acts, including the dissemination of fake news. Now, this would specifically address the problem of trolls and anonymous accounts that may be able to avoid criminal prosecution or civil action simply due to the inability of the court to acquire personal jurisdiction over the offenders because of their anonymity. In a similar vein, just this very morning, it was reported in the local news that an esteemed retired Supreme Court Justice of the Philippines has opined that the penal code should be amended so that libelous statements that are made by an anonymous social media account would carry the presumption of malice, thus making it easier to convict them. I think the problem of being unable to run after the authors of anonymous libelous posts or accounts, or to hold them accountable to the law if they commit an offense, that's a problem that cannot be lightly discounted. But it cannot also be discounted that anonymity may enable freedom of expression for whistleblowers afraid of retaliation, for oppressed minorities who are working within unsafe spaces. And overbroad solutions that may have the consequence of chilling freedom of expression. I'm happy to say that at least in terms of jurisprudential doctrines in the Philippines, such solutions are disfavored and viewed more skeptically by Philippine courts. Next slide. And in the vein of seeking more precise and less overreaching new legislation to address fake news and doxing, I would just like to point out that there are potential existing solutions under current Philippine law. Solutions that are designed or that would entitle those whose rights have been violated by fake news or doxing that they could already pursue. And this include action for damages or torts under the Civil Code, which would allow for indemnity for willful or negligent damage, loss, or injury that is contrary to law, morals, good customs, or public policy, as well as for acts or omissions that are accompanied by fault or negligence. Then there are remedies that those who may have intellectual property rights can pursue against fake news creators, because like in the Philippines, a lot of fake news is being disseminated under the pretense that these are coming from legitimate news sources. And one way to stem fake news without having to resort to overbroad legislation would be for intellectual property rights holders to actually pursue their remedies that would at the very least allow for civil injunctions against the further use of their intellectual property. But again, I would caution against overbroad legislation that may have the unintended or perhaps more sinisterly intended consequences of chilling freedom of expression in a more comprehensive manner. So that's the end of my presentation. Thank you again to LAWASIA and American Bar Association.
Oliver, thank you very much for that very comprehensive presentation. A good overview of the landscape of the laws in the Philippines, although not addressing the issue directly, but taking it on in several different ways, the point where I think it is being addressed in the Philippines. Thank you again. I now want to move to the questions that have been sent to us, and there are a few. But I'm very interested by the question that has just been actually put in the chat box, which I think is a good way to start the discussion, and it deals with fake news. And there's a long preamble to the question, the history about what has happened in the US and indeed in Malaysia. But if I may, with the permission of the participant who has put the question, summarize it in this way. And it's this: basically, who defines fake news? Right? Who defines fake news? Who has the last word on what is fake and what is not fake? And are there any examples of successful policing of fake news? I think the second part of the question is tailor-made for Phil to tell us whether he's seen it ever work in any jurisdiction, but it's open to all our panelists. But I'll start with Phil. Phil, who defines fake news, and have you come across any successful examples of policing of fake news?
Well, so far, the governments have really been defining fake news, and they have been defining it often without adequate consultation with bar associations and practicing lawyers, with NGOs, with journalists, with others. I mean, and that is part of the whole problem that we've seen, frankly, is that there's no participatory element to determining these issues, and ultimately the legal definitions that are provided in both law and regulations are insufficiently precise to clearly indicate when somebody has run afoul of that law, that provision, and that has been the core of the problem. That it really rolls up to the issue of the fake news is in the eye of the beholder, and it reminds me in some ways that everybody has a different definition of who's a freedom fighter. Depends on where your political inclinations are. Now, I mean, I think that there have been some clear indications of basic falsehoods. What has happened to, for instance, Alex Jones of the website InfoWars in the United States, where even with the U.S.'s very strong protection of freedom of speech, he has been found guilty in numerous district courts of basically making things up. And, so that's a clear indication. I mean, what I would argue for, frankly, is that there has to be governments have to have a robust counter-information operation, in the sense that if they believe that something is fake, they should be arguing why it is, and they should be doing it in a way that contests and creates a competition of ideas rather than simply shutting down the other side. And we would be in favor of that kind of discussion rather than the sort of effort by governments to criminalize online expression in a way that is creating a chilling effect across the region.
Robert, would you like to share the Hong Kong's perspective on who has the last word on fake news, and whether you consider the policing of fake news, if at all there is? I think focus more on doxing laws, but if at all there is in Hong Kong, as being a successful experiment?
It's difficult to say because we don't have the Hong Kong experience on fake news yet. The government is looking into legislation, but I think it is worrying as to who defines fake news, and there is the possibility of a chilling effect on journalists, and that's what journalists are afraid of in Hong Kong. So there has to be actually a fairly clearly well-defined line over which journalists cross at their own peril. But right now, what is worrying for many is that the line is not well defined.
And Oliver?
It's a very difficult question to even consider defining or criminalizing fake news. In fact, I think there are existential problems in that fake news could arguably is just current fake history. And if you start debating about historical facts stretching back from decades or centuries, you may even come into assaults as to existential questions about identity. So it's a really difficult to allocate or even establish a precedent of allowing for a governmental authority to predefine what's fake and what's true. Now, in the Philippines, and I'm sure in many other countries as well, you do have the prolonged, quote-unquote, due process procedure of proving and trying facts in court in case that there are viable causes of action that would be pursued. And the rhythm of proving facts in court is, of course, very different from the rhythms by which fake news move, because they're intended to cause they're not intended to provoke deep scrutiny upon the part of the reader. But there is a judicial process that could allow for the thorough vetting of facts. And in case that you do need to allocate to a particular authority who determines truth or not, I think the judicial process right now is one of the best options, slow as it may be. But we can hope that it can be a thorough and an independent process.
Thank you, Oliver. Bearing in mind that the discourse today is to really assist, to also assist bar associations when they grapple with these kind of problems, and hence the point or the query I posed to Robert just now as to what was the response of the Hong Kong bar to the amendment that was passed on 29th of September 2021 to your privacy ordinance. Now, in that way, can I ask you to consider this? Bar associations surely can play a role in defining what they consider to be fake news, and there are certain basic principles, if I may. And one principle is this, and it's a common law principle. It's called the Legality Principle. That if you're going to deprive fundamental rights, you can't do it by unclear or ambiguous words. If the words are unclear or ambiguous, then the fundamental rights enjoy the full birth of the rights, and there are no dilutions to it. So you must be very clear. So that's there. So that's perhaps the starting point for bar associations. But what's the approach? What approach would you suggest that bar associations can take faced with fake news laws? And Phil has mentioned also Malaysia, and I'm very familiar with it. Under Ordinance Number 2, under the Emergency Ordinance Number 2, it is very broadly cast, and indeed is still a subject matter of challenge in court, so I shouldn't say too much about it. But that's a good example of how it is put in a way in which it can be abused. And it is for the bar associations then to set certain parameters. Robert, would you have any views?
Well, Stephen, I think the bar or law society's input is particularly important in Hong Kong right now, particularly when there is very little to hold the government accountable. But there is always this tension because what might be perceived as comments on the rule of law might be perceived as comments in a political manner. I mean, politics should really be left to politicians. Unfortunately, we have politicians of one sort or one side only right now. So it's difficult, but it is important that the bars and law societies should speak out, but on rule of law matters. Now, specifically in relation to the Privacy Data Protection Ordinance, the bar did not speak out. There was a fairly short consultation there was a consultation in May. The bill was in July and passed in September, and all that was with the summer holidays in between. Well, our legislature, even if it is for whatever criticisms you can say, or launch at it because of its one-sidedness, it's certainly efficient, much more efficient nowadays than it was before. But back to the question, yes, it is very important for the bars to speak up, and even more so when the politicians may be less willing to speak up on any particular point about the law. Yeah, that's all.
Thank you, Robert. I'll put the same question to you, Oliver, because really, how prescriptive must these fake news laws be? And when they fall below those standards and you see that it could be an instrument of abuse, I would think the Philippines bar would speak up and say, look, if you're going to go down this route, then these are the parameters. Has that been done? And do you think it should be done?
Yeah, the Philippine Bar, the Integrated Bar of the Philippines has had a history of making public statements concerning pending legislation, usually casting a critical eye, or even just speaking on political matters that may run against the political tide. So, and whenever the Integrated Bar intervenes in that way, it carries a lot of weight. They get listened to. And in fact, politicians, some politicians, at least those who may be targeted by those statements, they get irritated and make statements to the effect that why is the Bar Association, why is the IBP being political? So, but it is also it is really dependent on the leadership of the Bar Association, how frequent, how vigorous they would intervene. So, but I could say that whenever they do make an intervention, making a public statement, for example, or even going as far as hosting fora or trainings on these issues, those interventions tend to be quite powerful, if only because they perhaps are quite rare. So when the bar does intervene, it sends a signal that this is a really serious concern.
Sure. So I think we can agree that when faced with this ambiguous words, which then can lead to sanction for fake news, bar associations would be the first to protest, to say that, look, if you're going to be depriving rights and if you're going to be imposing sanction, then you better be clear about it, that people must know. It mustn't be left to the judges trying to work it out and then either falling on the right or left, and depending on where they fall, you face consequences. I would imagine, Phil, that Human Rights Watch, because you're in the forefront of this, and you have the benefit of actually looking at possibly better than any individual bar association in a comparative way, the fake news laws that have come up in different jurisdictions. Have you looked into perhaps coming up with some sort of what I think lawyers would call a boilerplate or a standard form as to, if you're going to have fake news laws, as it seems that you all want to have it, governments, then this is a standard form that balances your concerns, that should not be misinformation to the prejudice of the people. But on the other side, it should not be a tool to curb genuine criticism of the government. Is that something that Human Rights Watch has looked at in terms of coming up with something that we all can latch on to say, there you are, that's the gold standard, if you like?
Yeah, I mean, I wish I could say that we have, but in fact, I think our approach is, I think first of all, the approach would be very much what you're saying in terms of the principle of legality that you articulated, because, almost all the laws we're seeing fail that. And, getting some actual clarity in what is intended by a fake news law I think is pretty critical also to being able to develop the ability to challenge that law, particularly if the implementation is off from where that law is clearly saying it wants to go. But we have not come up with a sort of model law there, in part because our feeling is that this concept of fake news really rolls very quickly over into censorship. And our feeling is that it's probably better to push back on this, to hark back to the various different UN special expert opinions in terms of what constitutes freedom of association, what are the limitations that can be applied on freedom of expression. There are a number of different articulated standards there that the Committee on Human Rights and others have brought out. The special rapporteurs on freedom of expression continue to do very groundbreaking work. And so what we would do is we'd say any bar that wants to take this on, I think, should really sort of dig deep into that international law on the human rights side and articulate a set of principles, perhaps, that should guide any discussion. Whether it results in finally a law at the end of the day is probably something that we would not take a position on unless it was clear that the law was violating those international provisions. And so I think we're trying to resist giving too much leeway to governments. The problem with the fake news discussion is that it is so easy to weaponize. And that is what we have seen continuously. It's a very easy line of attack to say, you know, this is fake news, and just to sort of dismiss an entire set of perspectives as being false or fake. You know, and this is being used in a very crude way, you know, by governments like Cambodia, you know, in a way that I think is really astonishing. And, you know, I mean, instead of government leaders responding to actual criticism, you know, they just reply that this is fake news. You know, we've seen this from President Duterte. We've seen it from leaders in Malaysia. We've seen it from leaders in Thailand. And it's just not the way to go. I mean, there needs to be some sort of provision for an ongoing discussion, which I think that the Bar Association should play a central role in, because you all are in some ways a sort of articulator of law and explainer of law to wider publics and also to your members. And I think that, you know, having the Bar Associations at the table operating on the basis of that international human rights law and what should be considered is really rather critical.
Thank you, Phil. Indeed, thank you, Robert and Oliver as well. We've had a very good discussion. Unfortunately, we've run out of time and we can't take any more questions, but I would urge you to look at the chat. There have been some very interesting and good comments on the chat, and thank you again to the participants for the comments that you have made. I think it really comes down to this, is the point that I tried to make at the beginning, and I think that is the tension that remains. On the one hand, you have the rights, which are fundamental rights, the right to speech and free expression. And in the hierarchy of rights, it's been said that these rights actually enjoy a prominence over many of the other rights that we consider to be fundamental. So that's the first point. And when you look at it in that sense, then the principle of, which is actually a principle of constitutional interpretation, that when you have the rights on one side and then you have restrictions, and both fake news laws and doxing laws, if you look at them, they are restrictions on these rights. And when one looks at these laws, the first point of reference is this: we would say that we will be reading down the implication of these laws to the point where they cannot in any way restrict to the point where restrict fundamental rights to speech and expression to the point where it becomes illusory and unworkable. So that's, I think, the point, the balance that we must draw. The balance that we must draw is you read down fake news laws, you read down doxing laws to the point where they must fit into the rights. If they don't fit into the rights, then they cannot be sustained. I would submit to you that that may well be a balance that we can have. But certainly, I would like to hear any last comments that you have before we wrap up. And I'll start with Robert first.
Thanks, Stephen. Yes, I entirely agree that we do need to be careful, and these are derogations of free speech rights. But of course, I think a proper balance has to be drawn, because there are serious implications for with fake news and also doxing. These are real problems. If you are on the receiving end of it, of being doxed, then that is very unpleasant. But at the same time, we do need to ensure that the everyone's right to receive information, that's from the doxing point of view, is protected, so that things can be as transparent as possible, so no one can hide under these laws.
Thank you, Robert. Oliver, any final comments?
Well, my own, as my last slide hinted, my own personal preferences would be, rather than fake news or doxing being addressed through comprehensive legislation that could go overbroad, the focus perhaps should be on enabling or better facilitating private individuals whose private rights have been injured being able to seek remedies under current laws. And I think that approach would more likely avoid overbroad and legislation that could be used to, for more sinister purposes. Thank you, and thank you to everyone.
Thank you, Oliver. And Phil, last comment.
Yeah, I'd say two things about this. I mean, I think on the whole issue of doxing, you've really got to balance the right to information versus the right to privacy, and there has to be some balance there. And how that is worked out, I think, is something that has to involve various different interlocutors and communities to figure out the right balance. On the issue of what Oliver mentioned, I mean, I tend to agree. We're very reluctant to have a widespread blanket legislation on fake news laws. I mean, I think if we could get in Asia, where we had moved away from criminal libel law, getting rid of criminal libel and creating just civil libel laws, where people have the opportunity to then take action to defend themselves against something they consider to be libelous without sending people to prison, then that would be the way to go. But we still, I mean, there's a whole nother conversation to talk about criminal libel laws in this region that that would take us another entire day. So I think that it's really important to push back against some of these laws that the governments are coming forward with, and I hope the bars in the region will be able to play a wider role in this, and will be given the opportunity to do so by the governments. So I want to thank you all for inviting me.
Thank you, Phil. Thank you, Robert. Thank you, Oliver, for those excellent presentations. It's been very edifying, and I think this is a discourse and a dialogue that can go on and on because there's so many issues. And indeed, I think the last word on any of this has not been mentioned yet. It is still very much out there. I'd like to also thank the audience, the participants who have been with us for this session. I hope you found this useful. I wish to also inform you that the third installment in this series is on the 9th of February, and we'll be looking at emergency laws at that session. And you know that during the pandemic, a number of countries, and Phil has mentioned it, I mentioned it, Malaysia is one of those countries that put in place emergency laws for purposes which I think are quite questionable. So that's going to be another very interesting discourse. We'll have 3 jurisdictions presenting on that day, and we hope to see you join us. Thank you again, panel members. Thank you again, participants. Have a good day.
Thank you.